This is the American Law Journal.
Does money equal free speech? Are corporations people too? If there's too much money in our democratic process, is the Supreme Court part of the solution or part of the problem? Good evening, I'm Christopher Naughton, and how does our country view this current Supreme Court and its relationship with big business? Is it too business friendly? Is it pro-corporate? Let me get the opinion of my four distinguished guests this evening. The Honorable Edward Kahn is with us once again, a former federal judge. He now arbitrates matters and is an attorney with Blank Rome. Danielle Franco Malone joins us this evening. She is legislative counsel with the Alliance for Justice in Washington, D.C. She's co-writer of the film A Question of Integrity, Politics, Ethics, and the Supreme Court. Chapin Cimino joins us for the first time this evening. She's an associate professor of law at Drexel Earl Mack School of Law in Philadelphia, and she's with the American Constitution Society, co-founding the Philadelphia chapter in 2003. And the Honorable Gene Cohen joins us once again, a familiar face here, a former Pennsylvania Court of Common Pleas judge, and now with Montgomery McCracken. Before we begin in earnest, let's go to the political pundit, Colbert.
If everyone on the Supreme Court had to recuse themselves every time there was a conflict of interest, we'd never get to see John Roberts' NASCAR robe.
Judges always like when the litigants stipulate before the court because it makes things easy. So let me go to each of our panel members tonight and see if we can stipulate. May we stipulate to this fact, which may or may not be in evidence, and whether it's actually true or not, that the perception in America, a la Colbert, is that the Roberts Court is a pro-business friendly, pro-corporate court. What do you think?
I don't think so. I think the public has great respect for the Supreme Court and will follow their edicts. I think they're held in a higher esteem than the material we're talking about portrays.
That's one no vote. Danielle, you are a co-writer of the film Question of Integrity. You used that clip in the movie. What of it? Do you think that America is beginning to sense or believes that this court is maybe unduly business friendly?
I think there is a growing realization that corporations are unduly favored at the Supreme Court, and a growing frustration by everyday Americans that they may not be getting a fair shake at the Supreme Court. I think that that's something that is catching on and that the public is becoming more aware of. And I think that's important, that the public really have an appreciation for how important the judiciary and the Supreme Court is and how it affects their everyday lives. And I think we're seeing more of that.
Okay.
I would like to say that I don't think there's a realization in the public mind. I think there's just a perception. Whether it's true, if we would study the opinions of the Supreme Court, we would find that it's not quite all that pro-business. There are cases which have been high profile, which have appeared to have favored business, especially dealing with the class action at Wal-Mart and the Citizens United case.
But the perception, Judge, but we've got you on the record saying you believe the perception at least is moving in the direction that more and more Americans believe that the court is pro-corporate. Did I have you on record for that or no?
Yes, I think
am I putting words in your mouth?
I think that's the perception.
Right.
I don't believe that it's necessarily the
True.
full reality.
Well, we're going to get to the substance in just a minute. We always do with you. But Chapin, what do you think? Do you think it's just in certain pockets of our culture that we're starting to see this sentiment, or do you think there's some real content, some real traction for this?
Well, 4 panelists, 4 answers. I think business lawyers might have that perception, maybe more than the average American. I'm not sure the average American could name Chief Justice Roberts as the Chief Justice of the Supreme Court. True. So if you're really asking about what do I think Americans think, I don't think they really give it much thought, other than, again, I think I agree with Judge Kahn that they hold it in some respect, but whether it's pro-corporate or I think probably if you ask my brother, who knows really nothing about court watching, he'd probably think criminal defendants get all the breaks at the Supreme Court. So I'm not sure I even agree that I think there's a public perception. Right. Business lawyers, I think, may have that perception.
Interesting. And you think even in the practice, Judge, that most folks are sober in their approach here and they wouldn't just give a knee-jerk reaction, the Roberts Court is pro-corporate?
I haven't come across any information that makes me think that the public is lacking confidence in the Supreme Court or in any other courts. There has been a problem in Pennsylvania with integrity in Luzerne County, but other than that, I think that the public holds the courts in high esteem, and I think the courts are doing a good job.
Well, it's interesting because Gallup poll just came out, and you're right, up to a certain point in time, Americans have held the court in high esteem, but I think in the political environment we've been here in the last decade, I think the Supreme Court's getting swept up in that. Today, I think with the social and the political and the monetary angst going on in this nation, I think the Supreme Court, rightly or wrongly, is being drawn into it, don't you think?
I don't think they have been.
Okay.
I don't think the Supreme Court can be blamed for the economy.
Not blamed.
For lack
We're talking
of
about
jobs.
perceptions right now.
The most important thing that's bothering the American public is the unemployment.
Right.
The Supreme Court has had nothing to do with that.
All right, here's Cornel West, who's gone up to the steps of the Supreme Court, and again, at least one noted figure is stating that some of the problems that we are facing in this nation is not simply due to the president or due to Congress, it's also the third branch of government. Danielle, let me go to you. I know that Alliance for Justice in Washington, D.C. believes very strongly that this court is a corporate court, and that may be feeding into some of the social angst that we're seeing today. What of it?
I think that's right. Generally, the Occupy Wall Street and the 99% movement is coming out of this growing frustration with the public sense that the system is rigged in favor of corporations. And I think that a number of recent Supreme Court decisions really enforce that notion. Supreme Court decisions that restrict access to the courts for everyday Americans and insulate corporations for liability. The courts are supposed to be the one place where Americans can go and stand up against powerful parties and get a fair shake. But because of Citizens United and some of the other big blockbuster cases we've seen, I think that there's a bit of that sense as being eroded.
Mm-hmm. Let's talk a little bit about the Citizens United case. This is a case that I think you can get some average Americans, some people at least plugged into talk radio, again on the left or the right. What was the Citizens case? Why is that so important, and why is it so important to our discussion tonight?
Well, it's a First Amendment type of assessment, and the Supreme Court didn't want to preclude anybody from making contributions as a form of expression. Mm-hmm. Now, the other side of the coin to that is that it seems unfair to spend all this money on elections, and that's a populist concern, and I think it is an issue, absolutely.
Mm-hmm. I think the Supreme Court was wrong on that particular issue. The basic statement was that a corporation has the same rights as an individual, and that the freedom of expression and at least the First Amendment rights are the same for an individual as it is for a corporation. Therefore, a corporation can spend money endorsing a candidate, may not give the candidate money, but may spend money endorsing a candidate or even trying to defeat a candidate. The problem here is that a corporation, at least in my view, is a fiction of that it's a person. It's a product of a statute. And as a result, it doesn't have the same rights as a person, and its rights can be restricted and should have been restricted in this particular case. But the Supreme Court made this ruling and followed through with it. This was a 5-4 decision, right, which struck me as being more political than constitutional. Mm-hmm.
And Danielle, would you say that two of the chords that are striking some sense of identity with the American public are the issues dealing with money equals free speech and that corporations are people too?
Sure. I mean, the Citizens United case opened the floodgates to allow corporate money to pour into our elections. And I think that that decision really resonated with a lot of people, not only because of the effects that it's had, but because of the very aggressive way that the court went out of their way to make the ruling that they did in that case. They overturned over 100 years of legal precedent upholding campaign finance laws, and they reached out and answered a question that wasn't even before the case. So it was really an example of judicial activism in addition to, a very, what we would consider bad ruling.
I enjoyed the Supreme Court's reaction to the president's criticism at the State of the Union, where Alito was shaking his head no, and then Roberts felt compelled to say how he didn't like going to State of the Union addresses anymore, that the Supreme Court couldn't take the public criticism that's being heaped upon it.
Well, I understand why Justice Alito was upset about that, because if you read the opinion, there was a lot of really complicated stuff going on there that's not captured in these big sound bites like open the floodgates and overturned all of this. And, you know, corporations are people too for the first time ever. I mean, I don't agree with the decision, but I think to talk about it at that level of abstraction really doesn't do it justice and allows all of us to sort of get around what the Supreme Court actually really did have to decide, which wasn't overturning really a century of campaign finance jurisprudence, but really trying to sort out a complicated maze, layer after layer, regulation, amendment upon amendment, trying to figure out how corporations could or couldn't contribute to political speech. It's true that they're corporations, but their corporate character, and I'm sure Judge Cohen will disagree with me on this, doesn't, and this is what the court said, doesn't change the nature of their speech from political speech to something else deserving less protection, which that was the point that they were making. And the reason why, and this goes to what Danielle was saying, the reason why she said the court was very aggressive and was very activist, and to a certain degree that's true, although I think it was Justice Roberts' opinion, wasn't it, or was it Justice Scalia? But whoever wrote the opinion went through very carefully and said, here are all the reasons why we can't decide this on a narrower ground. We're basically forced to confront this broader issue. Can this money from corporations come from the general treasury, or does it have to be restricted to PACs the way it always has been in contributions? There's actually a lot more to it than these big, you know, dramatic, abstract sound bites really allow us to.
It seems like the Roberts Court cannot take public criticism in stride, and they react to it. And so, by the way, so this Danielle's group will, if it gets wider coverage and broader coverage, impact them, because people don't like to look in the newspaper and see their names on favorable light on a daily basis. And Supreme Court justices, in fact, I think Justice Brennan said they do read the newspapers.
Judge Kahn, you're
yes. The thought here is that the Roberts Court is pro-business, but this decision allowed labor unions to also make these contributions. And I believe the disadvantaged party, the Democrats, portray themselves as representing the working folk. They have more money for the 2012 presidential election than the Republicans.
And interestingly enough, too, the ACLU were political bedfellows, or amicus curiae bedfellows, with the U.S. Chamber of Commerce. You don't see that every day.
Right. There are more than one situation where you can pick one of these pro-business rulings and say the Chamber of Commerce represented the business interest, and then look a little bit harder, press a little bit more like Judge Kahn just did and said, well, this actually has more complex ramifications, and I think that's true.
Let me roll in a clip here from Tom Hartman, who's a very dedicated liberal talker out of Portland, Oregon, and he shares the dais here with Dylan Ratigan. But I think in some ways this may tap into at least some of the angst that's being felt on the left vis-a-vis the Supreme Court. Go ahead and roll tape.
It is not in the Constitution. In fact, Article 3, Section 2 of the Constitution says that the Supreme Court shall operate under rules prescribed by Congress. In other words, Congress could say, sorry, Clarence Thomas, you can't take money from the Heritage, from the Koch brothers and then rule in their favor. But they're not doing it. And while no Congress has ever passed a law saying money is speech and corporations are people, in fact, they've said the opposite. I mentioned the Tillman Act in 1907. You've got all the way up to McCain-Feingold and others. Hundreds of pieces of legislation, federal and state, that have tried to limit the power of money. And many presidents, from Thomas Jefferson to Grover Cleveland in his 1888 State of the Union speech, talking about the iron heel of corporate power on the necks of the average person, all the way up to today. You know, presidents have never said this, but 9 guys in black robes, men and women in black. Well, it's been 5 men in black robes, about 3 blocks from where I'm sitting right now, have said, sorry, guys, in a series of decisions from starting with Dartmouth College in 1915 through 1886, Santa Clara County, And then the Buckley versus Vallejo in the 1870s, First National Bank of Body in the 80s, and now Citizens United have said, no, sorry guys, corporations are the same as people, and money is the same thing as speech. And rich people, if they got a lot more money, they got a lot more speech than the average person. This is screwed up.
And the problem is, if money is speech and you have an auction democracy, then money wins the auction, and those who have the money control the auction.
Right.
And then when they control the auction to preserve their business interest. And in this case, that's being done at the expense of everybody in this country.
Right. So we got to figure out a way to get it.
What are they getting here? What are they missing?
Well, I think I just mentioned that the facts are a bit to the contrary, that there's lots of money on both sides. So that it's not correct that the corporations are skewing the playing field.
Mm-hmm. I do think it's important not to attribute too much, not to build the case solely on Citizens United, because while Citizens United is sort of the poster child for corporate influence in the court, because it really invokes the sense people have that we're losing our democracy, it's just really the tip of the iceberg. I mean, in this past term, the AT&T versus Concepcion case and the Wal-Mart v. Dukes case together are going to have the effect of keeping millions of Americans out of court and insulating corporations from liability. So the Citizens United's case is certainly important, but it's really just the tip of the iceberg when it comes to corporate favoritism in the court.
The AT&T case, why is that case so important to all of us?
This is a case that really is going to affect all Americans in their daily lives, whether they know it or not. The case essentially allowed corporations to write get-out-of-jail-free cards into contracts with consumers and employees. So when you sign up for a cell phone or sign a job application that has an arbitration agreement down at the bottom, you've already given up your right to sue in a court of law and to band together with others who have been harmed by the corporation in the same way. So the end result is really that it's going to make it nearly impossible for many types of claims to be brought against corporations and allow them to break consumer protection laws, civil rights laws, and other of our most cherished laws without any repercussion.
Well, I'm not sure that it's that deadly and that potential for this kind of situation, but this kind of Supreme Court decision could certainly be overruled by an act of Congress. Changing the Federal Arbitration Act, dealing with these kinds of issues.
Right.
This came to the Supreme Court without the guidance of Congress, and therefore they made their decision. Congress can change it. We don't need the Supreme Court to decide every single issue in American life or in American law.
But they are going to rule on issues like Lilly Ledbetter, for example, and then if Congress wants to go back and preempt the field, they can do that. Tell us why the Wal-Mart case that was decided last term is so important.
Well, actually, you're asking the wrong panelist. I'm not sure Walmart is that important. Okay. I think Walmart is an outlier. There are 1.5 million class members trying to be certified in one class. And reading the decision, you have a majority and a dissent. Here's the East and West and never the twain shall meet, really talking past each other on the issue of constructing what commonality in 23A requires. I mean, and it wasn't at all about businesses or employers or employees or discrimination. It wasn't about any of that. So
it was a lot about procedure.
It was a lot about procedure, and it was this really tremendously humongous class action.
But the import, Danielle, according to you, is that women that you believe should have been able to join together as a class and bring a discrimination suit against Walmart was basically just cut off at the chute right before it got a chance to flower.
Yeah, my fear is that after this case, it's going to be much more difficult to form a class action against a large corporation. The Supreme Court in Wal-Mart said that the women essentially didn't have enough in common to band together and bring their suit as one lawsuit, despite the fact that women were paid less than men at every position in Walmart. They were promoted less often, despite having longer tenure in many cases. Walmart gave managers in stores exceeding amounts of discretion. They didn't require jobs to be posted so that anybody could apply for them. Instead, they used a tap-on-the-shoulder technique that allowed individual managers to hand-select who they wanted for certain positions. So despite showing that there were these statistical patterns of discrimination and a corporate culture that allowed individual decision-making to the point that people were exercising their discretion in ways that resulted in discrimination, the court said that despite all that, these women didn't have enough in common. So I think in the future it could very well be much more difficult to fight this sort of widespread discrimination.
The real problem is that a class action of that magnitude could destroy Walmart. and it becomes an unfair playing field because the class action plaintiff's attorney in a class that could result in billions of dollars of recovery could eliminate one of the largest employers in the world and cause more unemployment than we already have.
So that's really interesting because here Judge Kahn's observation is the class mechanism is sort of saving, kind of being exculpatory in a certain way, not insulating Wal-Mart from any suit, but from one of this magnitude that in one fell swoop could destroy it. But on the other hand, and I know Danielle, I'm sure, wants to talk about this, the problem in AT&T is that allowing those sort of mandatory arbitration agreements not to be subject to state law claims. It's not federal, it's state law claims of unconscionability because they're exculpatory without being expressly agreed to. There, AT&T is allowed to invoke an exculpatory procedure. So you see the same kind of maneuvering around class mechanisms in different directions. And I think that's a theme that feels pro-corporate. I do.
But one point should not be lost here, which is that those individual employees at Walmart who thought they were wronged could get a lawyer, bring their action, and their lawyer is paid by Walmart if they prevail. And if they have as good a case as it's been postured tonight, lawyers will take that case on an individual basis or in a class that's much smaller than the one presented in the case before the Supreme Court.
Let me start with you, Danielle, and then I'm going to basically go around the panel. And really, what do you think the American public really needs to know right now about business and the Supreme Court? Why is it so important to the average citizen that may not even be paying attention to this?
This issue is really important because whether or not you're paying attention to the court, it is impacting your daily lives. If you have a cable contract, if you get TV, if you have a cell phone, if you belong to a gym, then the Supreme Court's decisions are affecting you. And like it or not, in many cases, and the blockbuster cases, it really has shown a very pro-corporate inclination. You're absolutely right that in the past few terms, there have been some areas that the court has been more pro-employee friendly, take retaliation claims, for example. But in the cases that have the broadest impact on the most Americans, the court has issued some very sweeping rulings that are going to result in corporations being insulated from liability to the detriment of everyday Americans who will be kept out of court as a result of these rulings.
Judge, why is this entire subject important to all of us as Americans?
Well, as she says, there's a closure of the courtroom door to some extent in these rulings, and that is troublesome, I admit that. But I take the example of the gym. She said that if you belong to a gym and there's an mandatory arbitration clause in your contract, and they don't let you use the machine you wanted to use, why shouldn't that go to arbitration? Why should that be a federal issue because you think perhaps as a gay person you weren't allowed to use that machine?
Well, let me respond back with a hypothetical answer to that, Judge. Let's say that the gym lured you in as a customer using deceptive practices that violated your state's consumer protection laws, and you may not even have realized that you've been scammed out of, let's say, 10 or 20 bucks a month if the rate was hiked on you, or whatever the deceptive practice may be. Using these sorts of forced arbitration clauses is going to prevent you from maybe even knowing that you have a claim, from finding a lawyer that's able to take your low-dollar claim and bring suit. So I think that there are many sorts of examples in all of these sorts of contractual relationships that you could be affected negatively.
That's a policy decision that the Supreme Court is tasked with making, and they've made it. You disagree with it. We live in a political process. It'll get played out.
And I would just say that there is legislation right now to undo the court's recent decision. We think that in the AT&T versus Concepcion case, the court really rewrote the Federal Arbitration Act in a very expansive way, and there is legislation to undo that and bring the federal arbitration back to where it should be.
And that could be one solution to the issue if Congress speaks.
Right, Judge. Judge Cohen, that's what you've been saying. You say that almost every time you're on the program. If people don't really if the American people really don't like a Supreme Court decision, nothing's going to keep Congress from making that change. Again, let's look at Lilly Ledbetter. That was a celebrated case. A lot of people said, hey, this Roberts Court is not giving a fair shake to women. You know, they only have 180 days to go back and look at discrimination. Women have been discriminated, unequal pay for 10 years. And what happened? First bit of business that Obama put a pen to when he stepped up was the Lilly Ledbetter Act. It does happen.
And this can happen in many cases, except if it requires a constitutional amendment to reverse a decision of the Supreme Court. But I think that I agree what's important here, or at least in my opinion, what's important here is that the Supreme Court of the United States is probably the last institution where lots of people have reverence for it, and that it should maintain itself in that position of high authority so that when it makes a tough decision, like Brown versus Board of Education or the criminal defense cases, that people will listen and respect the decisions without trying to get around them or disrespect the law generally. So that the Supreme Court should act in the highest standards of the law. I wish the 9 justices would get together and have a code of conduct for themselves. So far, I haven't heard any of them suggesting it.
Chapin, you get the last words tonight.
Oh, this may be a bit deflationary, but your question was, how is this important to the person, kind of the general citizen, corporate litigation? I mean, the trend that I noticed when I go back and review the recent cases in the past couple of terms on the Roberts Court and whether or not it's been pro-corporate or not is not so much that it's pro-corporate, but it's suspicious of litigation. And I was reminded of this when Judge Kahn said there are some now decisions that are making it harder, and Danielle's made this point a couple times, harder to actually get into court. I do think that's true. And I do think some of those decisions that we label as pro-corporate aren't so much pro-corporate as they're anti or at least suspicious of plaintiffs' litigation. And that could actually affect everybody, because if we can't do class-wide arbitration and we do have to find a plaintiff's lawyer and the court's being highly suspicious of the plaintiff's bar, then where are we going to go?
I want to thank my guest tonight, Chapin Cimino.
Thank you.
From Drexel University, Earl Mack School of Law, and also a charter member of ACS in the Philadelphia region. Danielle Franco Malone with the Alliance for Justice Legislative Council and co-writer of the film A Question of Integrity. As always, the Honorable Edward Kahn, gracing us with his presence and his experience, the former federal judge, the former chief judge of the Eastern District of Pennsylvania. And, of course, the Honorable Gene Cohen, now an arbitrator, also a member with Montgomery McCracken, but for many, many years spent time on the bench in Pennsylvania. Folks, we are here every week. If you need more information, go to our website, lawjournaltv.com. Check us out on Twitter and on Facebook. Go to the website, get your law on demand. For all of us here at the American Law Journal, thanks for joining us. Until next Monday night, case closed.
This week's American Law Journal has been made possible in part by the Alliance for Justice, fighting for a fair America. Go to afj.org. The American Constitution Society, promoting the fundamental values of the U.S. Constitution at acslaw.org. Scheller PC, a national law firm preserving the constitutional rights of consumers since 1977. Martin Banks, remaining steadfast to its mission to defend and protect injured workers. And The Legal Intelligencer, the nation's oldest legal newspaper for lawyers.